Welcome back. Now, as artificial intelligence continues to become an integral part of daily life, its functions are sometimes abused. In recent weeks, the Legal Practice Council has had to deal with multiple cases, referred to it over lawyers using artificial intelligence to write legal documents. To discuss this, we are now joined by the Director of Legal Practice Council in Gauteng, Ignatius Briel. Ignatius, thank you so much for joining us this evening. Speaking about AI and all these online tools that we have as well to assist us, it looks like they're also being abused in the legal field as well. Tell us a little bit more about some of these cases that are being referred to you as the LPC.
So I think we see an abuse in two instances. So the prominent one at the moment is what's in the media, where practitioners use it to prepare for hearings of matters and then simply rely on the case law provided by the AI without actually checking it and reading it. Now, obviously, that's a major mistake. You cannot do that because firstly, you are not representing your client correctly, and you are also trying to mislead the court by quoting case law that doesn't exist. The other area where it is concerning is the number of candidates who apply for admission and have records from university days of the incorrect use of AI, which leads to plagiarism. And, you know, that's a disciplinary record that sits against that person's name and affects their ability to be admitted.
And I actually want to talk about the two-pronged approach. You're mentioning also from a student level, from when the lawyers are studying already, using these kinds of tools as well. Then it almost becomes like a crutch once you get into the professional space as well, because you've been already using it as a student. So I want to start there. If you could also just highlight maybe some of the warnings, because yes, these are tools that are supposed to help in making life easier, but if you could help to give advice for legal students as well about the dangers of relying on these tools.
I think the tool, as you said, is very important. It's a tool that can be used and is very powerful. But the onus always remains on the student to make sure that the work they hand in is their own work. That means you take the responsibility of actually reading the case law that you're referring to or reading the textbooks that you are referring to. You cannot simply just copy and paste from the internet and expect, to get a good mark and to get away with that. Because in essence, that is dishonesty. The use of it, I wouldn't say in itself is a problem. It's the responsible use that we need to pursue.
And also the repercussions of irresponsibly using it while you're still in your tertiary days, that it can then follow you in your professional space as well.
Exactly, yes. Yeah, because those students inevitably end up having to come and explain to counsel why they are still fit and proper to be admitted if there's a disciplinary record against them of being dishonest.
And you spoke about a two-pronged approach as we began this interview as well. Of course, the students and then the lawyers who are using AI tools for their citations as well. But the problem of them not checking the AI tools too. When you're speaking also to legal firms in the big top legal firms, in, for instance, in Johannesburg, one of them being Cliff Decker Hofmeyer, have also said that, look, some of these citations that the lawyers are getting from these AI tools are they look so real, they appear so real that it's almost impossible to tell the difference. And that's why then it is key to then double check. Why would you say, Mr. Briel, are we finding professionals using AI tools who are working and practicing as legal representatives, but not going through the process of just checking, just a double check?
I think it's become too easy to simply rely on the AI. There's a lot of time pressure on practitioners. The environment is becoming very competitive. And the time is the only thing that these practitioners have to sell, their time and their knowledge. So under this kind of pressure, they succumb to the temptation of just simply taking a citation without actually downloading the court record or the judgment and reading it for themselves. Because, simply, and it doesn't matter whether you get that citation from AI or whether you get it from a textbook or an article. You cannot refer to case law without actually having read the case itself. Because what you find in a citation might be somebody else's interpretation of that case. So it's absolutely critical that you do read. I don't think we should discourage the use of AI. As I said, it should be used responsibly. I think one of the big benefits of using AI is in the fact that it can assist in reducing the time required for legal research. As everybody knows, legal costs are quite expensive. So if there's a way of reducing the time spent to do the legal research, then that should be pursued, but it should be done responsibly.
What happens, Mr. Briel, in these cases where these lawyers and these legal firms are going into court and then they are using these tools irresponsibly so, and then it is discovered that you've used non-existent citation cases? What are the ramifications from the court side, and also what are the ramifications from the Legal Practice Council as the regulator?
From the court side, I do believe that our courts are still functioning very well. So inevitably, you will have the judge picking up that the citation used is incorrect. But the difficulty then comes the impact for the client, where there might be an adverse outcome for the client as a result of the failure of the attorney or the advocate to properly read. And then also it has the possibility of actually misleading the court, because our courts work on the basis that their decisions are very often based on prior decisions. So, if there's a precedent on a matter, they would inevitably follow that unless there's a very good reason to deviate from that precedent. So the risk is that the court is misled. From the LPC perspective, once these matters are reported to us, and I must say, we have not seen a lot of matters thus far. We have a few, but not that many. We would most likely investigate these matters on the basis of not acting as an officer of court and bringing the profession into disrepute. What the inevitable outcome of that investigation might be depends on how serious the contravention is. If it can be shown that there was gross negligence or mala fides in what was done, and there's an adverse effect as a result of that conduct, then the sanction might be harsher.
When it comes to those cases, as well, you're saying from the LPC side, you haven't seen that many, but you have seen a couple of those cases. One thinks of the Mavundla matter that also took place in January this year as well. How do you then rule on a case like that? That was a bit high profile as well. Do you rule on it as the LPC based off if, for instance, the legal firm says, look, it wasn't our intention to mislead the court, which has happened before, and they've apologized, and then there seems to be a moving on? Or is it more rigorous? Are there more repercussions to it? It's not as simple as an apology or a slap on the wrist.
Look, it's very difficult to say. The disciplinary process is conducted by independent committees. We actually need to assess each matter on its own merit. So there would be evidence led from all parties involved, specifically also with regards to the repercussions of that error that was made. And that would then dictate the nature of the disciplinary measure that's imposed against the practitioner. So it's not a question of a one-size-fits-all for all of these matters. And, the fact that a matter might be high profile in itself does not necessarily warrant a heavier punishment. It is the actual conduct of the practitioner, to what extent it could have been avoided, to what extent the practitioner shows remorse and attempts to correct his or her ways, that will impact the type of sanction that's imposed.
Mr. Briel, thank you so much for speaking to us this evening about this really important conversation